They say that democracy dies in darkness, and at 1:30 in the morning on Tuesday, June 22nd, the Canadian House of Commons passed Bill C-10. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. And yes, for those of you who may not know, yesterday, as of the time of shooting this vlog, the Canadian House of Commons passed the infamous Bill C-10. Now, for those of you who may not know, Bill C-10 is the famous or now infamous bill that would require internet companies, internet platforms to be subject to the Broadcasting Act and the authority of the CRTC. And for those of you who may not know what the CRTC is, that is the Canadian Radio, Television, Telecommunications Commission. Now, we're going to get into some of the details on this, although I've discussed it in previous vlogs, but before we even get into where we're going, I do feel the moral obligation to remind everybody out there who may not know exactly what the Trudeau government is about.
Who exactly the Trudeau government is.
Justin Trudeau has a knack for putting Canada in international headlines, and typically when that happens, it's always for the wrong reasons. It was less than 5 years ago we made it into the headlines of the New York Times. Trudeau holiday on Aga Khan's island broke ethics law, report says. Now, this was the first of Justin Trudeau's ethics violations, and for those of you who may not know what happened, just the brief overview as described in Wikipedia. Aga Khan Affair. The Aga Khan Affair was a political scandal in Canada involving Prime Minister Justin Trudeau. In 2017, Trudeau was found guilty of violating sections 5, 11, 12, and 21(1) of the Federal Conflict of Interests Act by accepting private island vacations, gifts, and flights from the Aga Khan, a philanthropist and spiritual leader of the Shia Ismailism movement. This was deemed significant as the Aga Khan Foundation, a registered lobby, had received over $50 million of federal funding in 2016. Justin Trudeau adopted the position that he and the Aga Khan were close friends, and the trips were of a personal nature. This was ostensibly supported by a close relationship between Trudeau's father, Pierre Elliott Trudeau, and the Aga Khan. Furthermore, in 1983, when Justin Trudeau was 12 years old, their two families had undertaken a vacation together to Greece. So Justin Trudeau's defense to this apparent conflict of interest and ethics breach is that he and the Aga Khan are close personal friends, while the Aga Khan's foundations are receiving $50 million in federal money.
I'm not sure that that's much of a defense.
So just to give you some insight into the judgment and ethics of this particular Prime Minister and this particular administration, Justin Trudeau did not think there was anything remotely problematic about accepting tens of thousands of dollars in vacations, gifts, and whatever from the Aga Khan, while the Aga Khan's foundations were accepting $50 million of federal taxpayer dollars. Oh yeah, and it's not just that Justin Trudeau himself accepted tens of thousands of dollars in gifts. Apparently that vacation cost the RCMP $56,000. RCMP owe the Aga Khan's island more than $56,000 for Trudeau vacation. The tab is for meals, accommodation, and jet ski rentals during Trudeau's Bahama holiday. But don't worry, apparently the jet skis were necessary only for security, and the RCMP will not disclose the details of who rented the jet skis or how many were rented, because that could jeopardize security to Justin Trudeau and his family. This is the world in which we live. This is the administration under which we've been living for the last 5 years. But as the classic meme goes, but wait, there's more. The SNC-Lavalin affair was a political scandal involving attempted political interference with the justice system by the Prime Minister of Canada, Justin Trudeau, and the Prime Minister's office, PMO. The Parliament of Canada's Ethics Commissioner, Mario Dion, found that Trudeau improperly influenced then Minister of Justice and Attorney General Jody Wilson-Raybould to intervene in an ongoing criminal case against Quebec-based construction company SNC-Lavalin. The Trudeau government has maintained that there was no undue pressure or law broken, that offering SNC-Lavalin a deferred prosecution agreement, DPA, could save jobs, and that the controversy resulted from a misunderstanding and an, quote, erosion of trust, end quote. Yeah, an erosion of trust, as in Justin Trudeau no longer trusts his own Mojag, the Minister of Justice and Attorney General Jody Wilson-Raybould, who he himself appointed to make the proper decisions, and so he pressures her not to prosecute SNC-Lavalin, to enter into a deferred prosecution agreement, and when she refuses, he demotes her. Yeah, an erosion of trust. And by the way, there cannot be an erosion of trust where no trust exists in the first place. That was Justin Trudeau's second ethics violation, and he had a number of other scandals which didn't necessarily result in ethics violations, the first of which was apparently having groped and apologized for having groped a reporter back in 2000. The second was obviously the images heard round the world of him dressed in a skin tone slightly darker than his original skin tone. And the third was the We Charity scandal, where apparently Justin Trudeau's mother and his wife were receiving payments from the We Charity for speaking fees to the We Charity events, and lo and behold, the We Charity was granted a sole-sourced, no-bid government contract to administer something like $1 billion in student loans, for which the We Charity would receive $20 million in payment. This is the absolute state of Justin Trudeau and the Justin Trudeau administration, and the collective population has a very short memory. If they ever had this information in the first place, people tend to forget the atrocious scandals that have affected this administration and that illustrate a lack of ethics, a lack of transparency, and a propensity to total corruption. So with that in the backdrop, let's now get to this Bill C-10, which just passed the House of Commons Tuesday morning at 2:30 in the morning. Oh wait, you know what? I actually spoke too soon, because there is yet another scandal affecting the Justin Trudeau administration, and lo and behold, it again involves making potentially preferential payments to potential friends or connections to the Liberal government. From the Globe and Mail, the Liberal Research Bureau, a taxpayer-funded office that supports Trudeau government MPs, used parliamentary money to hire a company that plays a key role in the Liberal Party's re-election efforts. Commons expense records show the Bureau paid more than $75,000 to Data Sciences Inc. in the period between August 1, 2019 and October 1, 2020. Data Sciences, a Montreal-based company, is owned by Tom Pitfield, a childhood friend of Mr. Trudeau, who ran the Liberals' digital operations in the 2015 and 2019 elections. He is expected to take on the same role in the next general election. Mr. Pitfield's company is known for using algorithms to target and adjust digital advertising during elections. This spending is in addition to separate payments made from the taxpayer-funded office budgets of Liberal MPs to Data Sciences and another campaign-related company, NGP Van, which makes software used by the U.S. Democratic Party that the Liberals license to run their Liberalist election database. Just more of the same. The more things change, the more they stay the same, or as we say in Quebec, plus ça change, plus la reste le même. Now let's get back to this 2:30 in the morning passage of Bill C-10. From Michael Geist Twitter, @mgeist, at 1:30 a.m., Bill C-10 passes 196 to 112. And for those of you who don't know who Michael Geist is a a law professor and Canadian research chair in internet and e-commerce law. Now, what is Bill C-10? I've talked about it in previous vlogs. Bill C-10 is basically an amendment that would apply the Broadcast Act to the internet world, because for those of you who don't know, in Canada, we have something called the Broadcast Act, which basically imposes certain requirements on television and radio as relates to the type of content they can play, the amount of Canadian content they have to play, and obviously financial penalties that they could incur if they don't respect the law. The Broadcast Act was passed before the advent of the internet, and the Canadian government now sees an amazing opportunity to make some money off online content, so they can go out there and apply the Broadcast Act to the likes of Netflix, YouTube, etc. Now, the concern from the very beginning was that this Bill C-10, if it were to apply like a blanket to the internet, would gobble up user-generated content and apply to and govern user-generated content, and so an exclusion was initially included in Bill C-10 to specifically exclude user-generated content. But then again, perhaps not in the dead of the night, but certainly under the cloak of darkness, that initial inclusion of the exclusion was itself removed, such that the exclusion was no longer included in Bill C-10, such that Bill C-10 would ostensibly apply to user-generated content because the exclusion was no longer included in the law. But on the issue of this, our Minister of Heritage, Monsieur Guilbeault, assured us that they had no intention of governing user-generated content.
I'm going to flip the question for a moment here, Minister, because it was important enough to put that exclusion there in the first place. Now it's gone. Why was it important in the first place to put it there?
We're not interested. I mean, it's not what the bill is about.
I mean, I hear you saying you're not interested, but there literally was an exclusion that was put in the original iteration of that bill, the thing that was reviewed, and then it got to committee, and bingo, bango, bongo, the exclusion is gone. So why was it important to put it there in the first place, such that now the committee has removed it?
Well, I mean,
and because politicians are politicians and have the propensity to speak out of both sides of their mouths, sometimes at the same time, just a short while later, Mr. Guilbeault in fact confirmed that Bill C-10 would actually apply to user-generated content if the user-generated content was big enough.
Do you understand? If the CRTC is regulating discoverability of Canadian content on social media, that is regulating social media. You are now calling user-generated content programming, and so it's subject. Like, this is the fundamental debate. I feel like we're driving past each other here. If the CRTC can put that, you're regulating it.
You have, as I said, individuals are exempt from this law, or will be once it's adopted. And what we want to do, this law should apply to people who are broadcasters or who act like broadcasters.
What we want to do, this law should apply to people who
are broadcasters or who act like broadcasters. So if you have YouTube channels with millions of viewers and you're deriving revenues from that, then at some point the CRTC will be asked to put a threshold. But we're talking about broadcasters here. We're not talking about everyday citizens posting stuff on their YouTube channel. It has to have a material. I mean, the criteria here, I think you're looking for it. It has to have a material impact on the Canadian economy. That's what we will ask the CRTC to look for.
So this immensely trustworthy, non-corrupt, and above all else, ethical government assured us from the very beginning that Bill C-10 would not apply to user-generated content. They initially included an exclusion to make that perfectly clear. They then quietly removed that exclusion from the law while assuring us that Bill C-10 would not apply to user-generated content, then discreetly admitted that yes, it will apply to user-generated content if the user is big enough. Nothing to see here, folks. Go home. Your freedom of speech is totally not under attack, totally not at risk of being censored by the government.
Unless.
But it is not all doom and gloom, because despite the fact that Bill C-10 passed the House of Commons, this bill is not yet law in Canada. It still has to get approved by the Senate, and then it has to get royal assent, and there are outside chances that that actually never happens. The Senate is breaking for summer, so they're not going to get to look at this law for the next little while, and there is an outside chance that if there is a federal election called before the Senate can actually approve this bill, that the bill might just actually die, and it will be up to the next government to pass it if it wants to. From the Globe and Mail, senators push back on Bill C-10 after MPs approve controversial internet regulation bill. Members of Parliament have passed Bill C-10, an update of Canada's decades-old broadcasting regime, but senators say the legislation needs more study and are declining to pass it quickly into law before Parliament's summer recess. With Parliament set to break for the summer on Wednesday, and with a possible fall election looming, the government is rushing to pass important pieces of legislation. MPs have been working late into the night, and Monday's sitting wrapped up around 1:30 a.m. Tuesday. So politics being what it is, and politicians being who they are, after having taken many, many months to draft, review, debate, and pass this bill in the House of Commons, they are now trying to jam it down the Senate to get it passed quickly before a potential fall election where, depending on the outcome, this bill may effectively die if it does not become law before then. Nothing like trying to cram down the throat of the Senate a law that could have potentially very disastrous effects on free speech and internet freedoms. So anyway, that is where things stand with Bill C-10. We'll see where it goes, but more important than remembering Bill C-10, remember all of the corruption of the current administration in the next election cycle. For anyone who has operated a small business, you know that the small business is only as good as its weakest employee. Well, the same holds true for government. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, and hit the notification bell. If you've watched until now and you're not subscribed and you haven't hit that notification bell, I don't know what more I have to do, but at the very least, leave a comment in the comment section because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
Robert Barnes and I do weekly live streams every Sunday where we talk all things law. We do weekly streams with a guest every Wednesday called The Sidebar, where we talk things that are not law. You can also find us and support us on Locals if you so choose at
vivabarneslaw.locals.com.
All of my content is also on Rumble if you want to follow me there, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!